So after you clearly identify the parties and you've ascertained their capacity, the next thing you should be concerned about is the Nigerian law will be used to define what goods are. In other words, what would party A be doing in this agreement and what will party B? In this video, we teach you how to prepare a valid contract without the help of a lawyer. I'm Godwin Salasi Dakbo, and this is Make It Legal.
Make it legal.
So after you clearly identify the parties and you've ascertained their capacity, the next thing you should be concerned about is the preamble of the contract. When we talk about the preamble, the lawyer calls it a recital. The recital outlines the purpose of the agreement. Why do you guys intend to enter into this agreement or this contract in the first place? What is the background to the transaction you want to engage in? You can outline all of that background or the purpose of the agreement in a recital. For example, you will say that Company A is a limited liability company that's the business of real estate as painters, while Company B is a limited liability company doing the business of indoor decoration, something like that. So you identify what they do. Then you said that the parties had discussions about the possibility of purchasing ABCD from Company D. And by reason of the discussion, they want to have an agreement that will bind the transaction they want to enter into. So that gives you a framework within which all the other things will be outlined. So first of all, be clear on the purpose of the agreement. Why do you guys want to enter into agreement? You have to ensure that that is stated at the recital or at the preamble. Now, aside the purpose for which you are entering to the contract, what you write in the preamble, you can also include the history that is leading to the transaction. What has happened before you are now going to have a contract? Did you have to have a meeting to discuss the possible terms? Did you have to make disclosures that you are willing to provide ABCD documentation to the other side, and then they should look at it to make a decision? Do you have to do that? What actually happened before getting to the stage you are now? Whatever discussions you had, that explains the history of the transaction or the need to enter into the contract can also be stated in the preamble. So most times when you see some contract, you will see the word whereas at the top. Where they place the word whereas, that is where they always state the recital or the preamble of the contract, outlining the purpose of the contract and sometimes the history that is leading to the transaction or the execution of the contract, or things that happened before there is the need now to have a contract. The fourth thing you need to know, which is important in preparing the contract yourself, is to ensure that you outline the obligations of each party. What would party A be doing in this agreement, and what will party B be doing in this agreement? So that must be spelled out. It devotes a clause to it to identify first the obligations of one party and then the obligations of the other parties. The fifth thing you should take note of is you should have a clause in the agreement that explains the effect of a breach of the agreement. What happens if Mr. A breaches the agreement? Should there be penalties for non-performance or for breaches of the agreement? Should interest accrue on monies that ought to be paid and a party fails to pay it? What should actually happen in an event an agreement or a clause in the contract is breached? Devote a clause to state exactly what you want to happen if the contract is breached. So that way gives you the expected outcome of a breach of the contract. So a party is aware that if he defaults in fulfilling its obligations, ABCD will take place, and that can in a way put the party in a position to ensure that he or she avoids that implication, and then they fulfill their part of the obligation. So you can decide that you put in the agreement the effect of a breach of a particular clause or the entire agreement. Point number 6 to note is termination clauses and requirements of notice. So when you also have an agreement, you should try to include in that agreement a clause that explains how a party can terminate the agreement. How do we bring the agreement to an end? Or if I want to be out of the transaction, I don't want to contract again with you, how do I come out of it? So there should be a clause devoted to explaining that. Oftentimes we explain that you should require the other side to give you a notice. It could be 2 weeks notice, 1 month's notice, or sometimes 3 months notice, of the party's intention to terminate the agreement or to cease to be under obligation to do the things that the agreement requires of the person. So it's a freedom to enter into the contract and there's a freedom to come out of it. So you should always outline in the agreement how you want either of you to be out of the agreement. So termination clause, and that is how we call it. Ensure that you have a clause that speaks to that. The seventh thing you should also note and ensure you have a clause that spells it out in the agreement is what the lawyer calls the governing law. That is simply the law that governs the agreement. Which law would regulate the agreement you are entering into? If you are Nigerian entering into a contract with a Ghanaian, which law should govern the agreement? Would you want the law of Nigeria to govern the contract or the law of Ghana? You can even decide that the law of UK or USA will govern the agreement. Nothing prohibits you from choosing a particular law. But you just have to know that whichever country's law you choose has a lot of implications. So oftentimes you are better off choosing the law of the parties to the transaction. If both parties are in Ghana, you are safer choosing the law of Ghana to govern the agreement. But if one party is in Nigeria and one is in Ghana, you know that the contract will be performed, say, in Ghana. You are safer choosing the laws of Ghana to regulate the contract. What it means is that if, for example, you mention the word goose in the agreement, the law that will be used to define that term should be the laws of Ghana if you have chosen Ghana as a governing law. But if you have not chosen Ghana as a governing law and you choose, say, Nigeria, when a dispute occurs as to the meaning of the word goose, the Nigerian law will be used to define what goose are. In other words, what is the word goose as defined under Nigerian law? That is what will be applicable to the resolution of the dispute. So just have that in mind, that you are at liberty to choose the law of a country that will govern your agreement. Nothing prevents you from choosing any country's law. But there are, of course, implications to choosing a particular country's law to regulate your agreement. Point number 8 you should note is dispute resolution clauses. Now, it's important to have in the agreement or contract a clause devoted to how you want to resolve your dispute when they occur. Do you want the matter to be sent to court when there is a dispute between the two of you or the parties to the contract? Or you want to go to ADR, that is alternative dispute resolution mechanism, to resolve the dispute? Or you want to go to either of them? Say you want to submit your dispute to arbitration or submit it to mediation or to some sort of negotiation. You have the right to choose which one you want. If you think the agreement is such that this one, if something happens, we all must head to court, then you leave it open and allow the court to be the decision that would resolve the dispute. Now, what it means is that if you don't choose a particular dispute, automatically the court will be the entity that will resolve the dispute when it occurs. So you are at liberty to prevent or prohibit or maybe deny the court the privilege of hearing your dispute. You can take it out of the court and resolve it either at mediation, arbitration, or negotiation. So you can choose it in the agreement before there's even a breach in the first place. So that is point number 8 for you. Point number 9 is special clauses. Now, are there certain conditions that you think are very special to the arrangement you are having now, that are very peculiar to the agreements you have as parties or the transaction you intend to enter into? Are there timelines that are crucial to you? Are there payment terms that you think are important to you? Those, I call them special clauses. You can put them there. Default clauses that outline all those additional conditions that you think should be part of your agreement. If you want it to be part of your agreement, please include it at once. If you don't include it in the agreement, chances are that you will not have it regulate the transaction. And if issues occur and you want to fall on it, it will not be permitted because it is outside the contract. That is point number 9 for you. The point number 10, which is the last one, is language. Now, you have to be very careful about the use of language. Of course, we're talking about English language here. When you are preparing the contract in English language, ensure that you use the right and simple words. Don't ever use a word in the contract that you don't understand. First of all, you know you're not a lawyer, so don't go copying a lawyer's agreement and use that as your agreement. The lawyer knows what he's doing. That is where he might have used a particular word to describe a number of things in the contract. Don't go copying it without knowing what those words meant. So before you take a template from the internet and begin to edit it. Just know what you are doing. To avoid those situations, simply avoid using words you don't understand. Use simple words. I want Kofi Mensah to provide me legal services, and I'm writing this agreement to engage him for the provision of legal services. Simple. It will still be legal. It will still be proper and effective. The words do not determine the legality of the agreement. It is the fact that it is what the two of you agree on. That is what makes it effective and legal. So don't be interested in making it look legal by importing legal terms that you don't understand because you're not a lawyer. Just avoid using words you don't understand. Use a simple language you know as an ordinary person in communicating your terms. Write it the way you understand it. That what it is you want should be what you should write. No need for legal terms. I believe with these guides you can be able to prepare a valid contract yourself. A very simple contract. You can prepare it by yourself, even if you don't have a lawyer who is there to help you prepare it. So take your time, watch this video again, and take your pen and paper and try writing that contract for the sale of that car you want to sell, or for the sale of that item that your friend wants to buy, and let's see how it looks like. Share with me in the comment section how this video is helpful to you and whether or not you think that it will help you prepare a contract yourself. And there are indeed some contract that you cannot prepare unless a lawyer is involved or a lawyer really takes care of the entire process. I have a next video coming up which explains to you all the contract that I will never advise you to draft or prepare or sign unless a lawyer reviews it for you or prepares it for you or is present and ensure that he supervises its preparation before you sign it. I will explain all of those contracts to you in the next video. If you enjoyed this video and you want to encourage us to do more of this video, please subscribe to the channel and click on like, and also share this video to a friend. And we would like to hear what you think of the video. Drop a comment in the comment section and we would read it and reply to you. I'm Godwin Selassie Dakbo, and this is Make It Legal.
Make it legal.